So where were we? We covered center-state relations, and then we covered, I think so, legislative relations, administrative relations, financial relations. In financial relations, we covered GST, GST Council, and so on. So just to test, exam question. Surcharge can be made applicable on GST. Come on, just to test, exam question. Surcharge can be made applicable on GST. No. Why, sir? Parliament made an act that surcharge will not be collected again on goods and services on which GST is levied. As of now, surcharge is not applicable on GST. You do understand what I am saying? Surcharge means tax collected on tax. But Parliament itself made it clear, as of now, due to implementation of GST, multiple slab rates are introduced, 0, 3, 5, 12, 18, 28. Instead of imposing surcharge, what we can do, we can move the goods or services from low slab to the next slab. You do understand what I am saying? Suppose earlier, on a milk packet, we were collecting 3% GST. Now instead of imposing additional surcharge, let's move that milk packet to 5% slab. That's the reason why surcharge is not made applicable on GST products. Instead, the goods and services will be shifted from one slab to other slab. So exam question. Surcharge is now not applicable on GST. Yes. So again, GST basket is widened. Correct? What do you mean of basket is widened? More number of goods and services are brought in. So to implement GST, GST network is developed. This GST network is collaboration of central government as well as state government, public as well as private. Public-private collaborated network called as GST network. So GST network is completely owned by central government. No. GST network is completely owned by state government. No. GST network is joint ownership of state government as well as central government, public as well as private. Again, so if you look at in implementation of GST, in case of IGST, look at the word. In case of IGST, only Parliament has the power to make the laws. Why, sir? IGST is applicable, integrated GST, only when production point is different, consumption point is different. So what is GST, sir? GST is a single point destination based tax. What is meaning of destination? Place of consumption is called as destination. Normally, GST will be collected in a state where goods or services are consumed. The consumption point is called as destination. If production state is same, consumption state is same, IGST is not applicable. Production state is different, consumption state is different, interstate trade is happening. Look at the word. Interstate trade is happening, then IGST is applicable. So who will make laws on IGST? Only Parliament. So which of the following statements are correct? Regarding SGST, both Parliament as well as state can make laws. Look at the word SGST. Regarding SGST, both Parliament as well as state can make the laws. How will they decide? In GST Council, in consultation with each other. But in case of IGST, only Parliament is authorized to make the laws. Why, sir? Interstate trade is under union. That's the reason why only in case of IGST, laws are made by Parliament. Clear? And again, I said something. GST Council recommendations are not binding on government. So because obviously during COVID-19 time, they filed a case in Supreme Court. Then what is the meaning of a revenue neutral state in GST? A revenue neutral state in GST means after implementing GST, a state income should be at least equal to that of what it was there in VAT. Before GST, the indirect taxes were there, several indirect taxes, sales tax, service tax, VAT. So GST did not replace all the indirect taxes. But when VAT was there, how much income the state was getting after implementation of GST, if it is more than that, there is no problem at all. But it should not be less than the previous. That is called as revenue neutral state. And GST buoyancy is more, and for the first time, single month GST collections crossed more than 1.92 lakh crore in April month. For the first time, from implementation of GST from 2017, in a single month, for the first time, GST collections crossed more than 1.92 lakh crore. So tax buoyancy is more in GST. What do you mean of buoyancy? Tax buoyancy, GST buoyancy. Any idea? Relationship between GDP and tax income to the government is called as tax buoyancy. If GDP is growing, what is expected of tax income also? Growing. So GST buoyancy is more in India. What do you mean of GST buoyancy is more? See, when production of goods and services is happening, tax is collected on that. More production, more tax. That is called as more GST buoyancy. Because GST is collected on goods or services or both? Both. But GST exempted goods are there. What are GST exempted one? Petrol, diesel, aviation, turbine, fuel, natural gas, correct? Alcohol. They are out of GST. Petrol, diesel, aviation, turbine, fuel, alcohol. So which are applicable? Respective state government excise duties applicable on them. That's the reason why there is price difference between one state to other state. Why do people go to Goa? Knowledge is divine. Knowledge is divine. So they want to drink as much as possible. Knowledge. That's the reason why they are going there. So it is the respective state government excise department which will collect the excise duty. That's the reason why alcohol prices vary from state to state. Electricity charges also vary from state to state. So these are GST exempted goods. Recently, Madam Nirmala Sitharaman said that sin tax will be collected on consumption of harmful goods as GST compensation cess. Look at the word. Sin tax will be collected on consumption of harmful goods as GST compensation cess. Who is supposed to pay GST compensation to the states? Center. So initially, center guaranteed GST compensation to states for 5 years. 2017 to 5 years means 2022. Now states are asking to increase GST compensation furthermore. So center is considering whether to extend or not. But as of now, to pay GST compensation to the states, center is collecting cess. I said what is meaning of the cess? It should be collected for specific purpose. So this GST compensation cess will be collected on sinful goods. That the reason why the tax is called as sin tax. Pan masala, tobacco, intoxicants. So if you consume sinful goods, tax collected on that sinful goods is called as sin tax. So GST compensation cess will be collected on consumption of harmful goods. So when you are seeing a movie, it will come. Smoking and drinking is injurious to health. ఆ 2 గాజులు అమ్ముకోవాల్సి వచ్చింది. ఎన్నిసార్లు అమ్ముతారు అయ్యే గాజులు మళ్ళీ. Which means something which is not so good If we consume it, it is considered as sinful and the tax would be collected. So GST compensation cess is extended. GST compensation cess is extended and sin tax is being continued. That's the reason why Madam Nirmala Sitharaman said. Then people made so many memes on popcorn. Correct? So because of multiplicity of the taxes collected on popcorn. Anyway, in multiplexes, popcorn cost is more than ticket cost. So better to make popcorn and take, no, they will not allow. But again, that is GST perception. But why GST is comparatively better compared to VAT, sir? Because of digitization, uniformity of the taxes, and just now we said, central states are promoting cooperative federalism through GST, CGST, SGST, IGST. So this is in brief about center-state financial relations. Then some committees are there on center-state relations. Not every committee is important, but sometimes they ask a question. So Punichi Commission, then Sarkaria Administrative Reforms Commission, all that. If you look at first Administrative Reforms Commission 1966, when under chairman of Morarji Desai, what did it suggest, sir? Interstate council should be established. Look at the word. Interstate council should be established. Suggested by which? First ARC. What is ARC? Administrative Reforms Commission. So who was the chairman? Morarji Desai. So not much, but out of all the recommendations, and see, it suggested a non-partisan person should be appointed as governor. What is the meaning of non-partisan person? The person should not be from any political party. Because even though governor is working as custodian of the state, but he is affiliated with some political ideology, so he is not functioning properly. So ARC says that appointment of governor should be non-partisan and maximum power should be given to state. More financial resources also should be given to the states. Look at the word. It suggested maximum powers should be given to the states. Not only power should be given to the states, but also resources also should be distributed to the states. But not much important. So remember this. Governor should be appointed from non-partisan. That is called as first ARC. Then Rajmannar committee, this is not appointed by central government, this is appointed by Tamil Nadu government. So it's not appointed by government, it's appointed by Tamil Nadu. Recently, in Tamil Nadu government presented budget, they introduced Tamil rupee symbol instead of India's rupee symbol on the budget paper. So they're organizing anti-delimitation committee meeting also. Meeting is going on. Yes? So again, if you look at, they have a feeling that they want a separate country called Dravida Desham. Dravida Nadu. Dravida Desham. Maybe. But again, so Rajmannar committee suggested so many radical reforms. What are radical reforms, sir? Abolish all India services. Rajmannar committee suggested radical suggestion, abolish all India services. Then what should we do, sir? And it's also suggested, interesting, residuary powers should be given to the state. Residuary powers should be given to the state. So obviously appointed with Tamil Nadu government. How will it recommend? So it suggested residuary powers should be given to state, abolish all India services. This is the recommendation of Rajmannar committee. Of course, state government only, so nothing to worry, because practically not possible at all. Just because a state government is saying, so it will not happen at all. Then Sarkaria Commission. So this was previous prelims question. In Sarkaria Commission, one of the popular recommendation, because a burning topic, current affairs also, 3-language formula. So what is 3-language formula, dear? So what is 3-language formula? As far as possible, promote mother tongue, primary education, also promote Hindi along with English. Correct? So Sarkaria Commission suggested to promote 3-language formula, which is being questioned by Tamil Nadu. Don't rub your Hindi on our head. That is their demand. So what is India's official language? Official language, not national language, dear. What is India's official language? Hindi and English. What is India's national language? No national language as such right now. Correct? So Tamil Nadu government is saying, no, we don't want to learn Hindi. हिंदी हमारा राजभाषा है लेकिन हमको नहीं चाहिए. So they are telling we don't want Hindi. Anyway, if you learn in English or if you learn Hindi, if you learn any language, it is good only. It will improve the skills. So take our own example, English medium students. Who are English medium students? No language is perfect. They are called as English medium students. I mean, including you and me. So, Hindi. Thoda pyar dalo bhaiya. English. Examiners are getting admitted into ICU after correcting answers. Telugu. Ashok Nagar వచ్చింది. అశోక్ నగర్ వచ్చిందా, అశోక్ నగర్కి మనం వచ్చామా? 3-language formula. So 3-language formula is actually suggested and supported by Sarkaria Commission. Actually, new education policy also is promoting. Go for 3-language formula. So apart from that, permanent interstate council should be there. It also supported interstate council. It suggested strengthen all India services. It suggested 3-language formula. Yes. Strengthen all India services. And one of its recommendations regarding governor, previous prelims question. So what is its recommendations regarding governor, sir? It says appointment of the governor should be from outside of the state. Appointment of the governor should be from outside of the state. That is the recommendation of Sarkaria Committee or Sarkaria Commission, which is asked in prelims exam. Governor appointment should be from outside state. Why outside state, sir? What is the reason? Sarkaria Commission said 1983. No political affiliation, no local influence. So the governor can act impartially. So one of the recommendations of Sarkaria Commission was governor should be appointed from outside the state as far as possible. It suggested to strengthen all India services also. Again, it said to avoid conflict between center and state, center should consult the states before making laws on concurrent list. Who should consult whom? Center should consult the states before making laws on concurrent list to avoid the conflict. So this is briefly about Sarkaria Commission. For exam purpose, remember, strengthen all India services, 3-language formula, center should consult the state before making concurrent list. Just now we covered appointment of governor should be from outside the state. Then Punichi Commission 2007. So Punichi Commission said it used the word cooperative federalism. Punichi Commission in its report itself used the word cooperative federalism. So already we know what is the meaning of cooperative federalism. Center and state and the state should work like a team in tandem with each other. That is called as cooperative federalism. Punichi Commission 2007. So it directly used Second Administrative Reforms Commission and said cooperative federalism. What is the meaning of cooperative federalism, sir? As far as possible, the state and the center should together take decisions, and center unilaterally should not take decisions on the states without informing them. Cooperation, sit together and try to promote. That is called as cooperative federalism. So Sarkaria Commission main recommendation, governor should be from outside state. Punichi Commission main recommendation, cooperative federalism. So these are some of the committees related to center-state relations. Then there is something called interstate relations. When we discussed about Supreme Court original jurisdiction, we said something. In interstate water disputes is not under Supreme Court original jurisdiction. Why, sir? Why? What is the reason? Parliament separately constitutes tribunals for resolving disputes related to interstate river water disputes. That's the reason why that is not part of original jurisdiction of Supreme Court. Remember? Center versus states, state versus states, center versus states versus states. We have listed out original jurisdiction of Supreme Court. But there, exemption is interstate river water disputes. Why, sir? Article 262. What does it say, sir? It provides for constitution of adjudication of interstate water river disputes. Meaning, what is mentioned in this Article 262? Two provisions are mentioned. Parliament may by law provide for adjudication of any dispute. Meaning, if any dispute is there between the two states, Parliament will try to solve it. Second, Parliament may also provide that neither the Supreme Court nor any other court can exercise jurisdiction in case of water dispute. Two clauses which are mentioned in Article 262. First one, in case of dispute among the states, Parliament will adjudicate. Parliament will try to solve it. Second clause under Article 262, Supreme Court or any other court cannot have jurisdiction over this interstate river water dispute. That's the reason why yesterday we said in Supreme Court original jurisdiction, interstate river water disputes are not there. But what about interstate boundary dispute? What is interstate boundary dispute? What is interstate water dispute? If you're following current affairs, something happened in Belgavi. So interstate water disputes is not part of original jurisdiction of Supreme Court because of this article. Clearly it says not only Supreme Court, any other court do not have the jurisdiction on interstate water disputes. What does it mean? Parliament will appoint tribunals over a period of time. And interesting, if tribunal gives judgment, is it binding on the parties? If tribunal gives judgment, is it binding on the parties? It is binding on the parties. So various tribunals are there. Krishna Water Dispute Tribunal, Godavari, Narmada. So Krishna, which states are filing? Or which states are fighting? Maharashtra, Karnataka, Andhra Pradesh. Godavari, Maharashtra, Karnataka, Andhra Pradesh. Narmada, Madhya Pradesh also, Odisha also. Narmada, Rajasthan, Gujarat, Maharashtra, Madhya Pradesh. Kaveri, Karnataka, Kerala, Tamil Nadu, Puducherry. Kaveri. Apart from that, Vamshadhara, Odisha and Andhra Pradesh. Polavaram, Karnataka and Telangana. No, it is not a dispute. Mahadai, Goa, Karnataka, Maharashtra. It's okay, no need to remember. Mahanadi water dispute, Odisha and Chhattisgarh. So current affairs here following newspaper. PM laid the foundation for first interlinking of the water project between Ken and Betwa. Between Ken and Betwa, connecting Uttar Pradesh and Madhya Pradesh, which are tributaries of Yamuna. The concept of interlinking of the rivers was first suggested by Mokshakonda Vishweshwaraya long ago in 1934. So, this is briefly about interstate relations. Then, Interstate Council is constituted under Article 263, but not that much important. So, in interstate relations, what type of questions are asked? Sarkaria Commission recommendation. So, governor should be from outside of the state. Again, federalism is a basic feature of the Indian Constitution. Yes, SR Bommai case, Supreme Court said these words. Federalism is a basic feature of Constitution. What do you mean of basic feature of Constitution? Remember basic doctrine? Basic section of doctrine? So one by one interpretation, we came to know about all this. Then what is fiscal federalism? Distribution of taxes between the center and the state in coordination with each other is called as fiscal federalism. What is asymmetric federalism? Asymmetric federalism means some special provisions are given to some special places. Different states are given special status. Jammu and Kashmir was given special status. Which article? Article 370? 370 only? So Article 371 to 371J, different special provisions are given for different states. So asymmetric meaning not similar. Different powers are given to different states, not equal treatment. So there is a different powers are given and different resources are distributed differently, not in the same way. That is called as asymmetric federalism. Then what is cooperative federalism? Already we covered. What is competitive federalism? States have healthy competition among each other. That is called as competitive federalism. You should also get selected. Your friend also should get selected. Competitive federalism. ఓ మంచి దేవుడా నా రోల్ నెంబర్ తప్ప మిగతా వాళ్ళు ఎవరూ పాస్ అవ్వకూడదు. నో, బాగా చదివిన వాళ్ళంతా పాస్ అవ్వాలి. సో ఫిజికల్ ఫెడరలిజం, కోఆపరేటివ్ ఫెడరలిజం, కాంపిటేటివ్ ఫెడరలిజం, asymmetric federalism. Again, residuary powers which are not ensured in any of the list is given with the center. Correct? Article 248. So similar to Canada only. Strong center. Residuary powers are there with the center. Canada stands for C. Center stands with C. C is matching. That's the reason why. Strong center. Residuary powers with the center. Of course, model from Canada only. Union list. How many subjects are there at present? Okay. State subject. How many are there? Concurrent list. Are they fixed or they keep on changing? Whenever constitutional amendment is done, some are transferred from one list to the other list. In the process, it keeps on changing. Again, we said something. So if you look at the three lists, union list, state list, concurrent list, India adopted this from Government of India Act 1935. The idea, we did not copy as it is, but the concept of distribution of powers of union list, state list, concurrent list, we adopted from Government of India Act 1935. Apart from that, interesting doubt. If 2 or 3 states ask the parliament to make a law, if 2 or 3 states ask the parliament to make a law, the law will be applicable only to those states. Think and tell. Answer is yes, because only those states asked. Did you understand the meaning of the statement? If parliament is making a law on a state subject in exceptional circumstances, it is applicable to all the states. Got the meaning difference? If parliament, now nobody asked a doubt, I am only asking a doubt. Sir, CGST Act is passed by government to implement GST from April 1st, 2017. Should state government compulsory follow? Should state government compulsorily follow? Come on dear. Consent of half of the states is already given. Consent of half of the states is already given. Each state introduced its own GST Act again to implement GST. Do you understand the meaning of the statement? Again, during national emergency, Parliament can legislate upon any subject in the state list. Such a law becomes inoperative on expiration of 6 months after the emergency in that state. Yes, emergency is over. Means what? In that state. In that state. What does it mean? What is the purpose of... Anyway, last topic is emergency only. Today we are going to cover. But Article 352, during national emergency, Parliament can make a law on state subject. That much is clear. Because our federal system gets transformed into unitary system. Again, if you look at, state has to comply with the directions given by the center in administration. State has to comply. Means state has to follow the orders given by the center. If it is not followed, what they can do? All India services are controlled jointly by the center and the state. Look at the word English. English problem, not polity problem. All India services are controlled jointly by the center and the state. Control. Who can suspend civil services officers? President. Suspend. An IPS officer is suspended by Andhra Pradesh government because he has done some naughty things in the office. Termination is done by the president and dismissal is done by the president on the recommendation. But who can suspend? State government can suspend here. There is a difference between suspension and termination and dismissal. Again, who can appoint, who can take disciplinary action? Disciplinary action, central government. Did you understand the meaning of the statement? Now look at the word. All India services are jointly controlled by the center and the state. Of course, the promotion, training, all this comes under central government. No doubt, DOPT. But who can suspend a All India service officer? State government can suspend. But who can dismiss from the service and terminate from the service? Of course, the letter to remove for that person will go to them and finally president will take. And union government. The constitution authorizes the parliament to create new All India services and it can originate in either of the houses. Rajya Sabha, already we covered Lok Sabha, Rajya Sabha, equal powers, more powers, all that. Now again, governor is a bridge between the center and the state. This bridge is not working properly. So, but ideally they are supposed to. Apart from that, surcharge is collected on GST. Surcharge is collected on GST. No, Article 269A clearly government said surcharge is not applicable on GST. Again, surcharge supposed to be shared by the center with the state. Surcharge supposed to be shared by the center with the states. No. The surcharges collected at the center need not be shared with the states because they do not part divisible pool of taxes as recommended by Finance Commission. What does it mean? All taxes collected by center are not shared with the states. Only divisible pool of taxes recommended by Finance Commission. So surcharges are not part of divisible pool of taxes, meaning center need not share surcharge with the state. Apart from that, distribution of non-tax revenues are discretionary power of the center. Look at the wording. Distribution of non-tax revenues, not tax revenues, non-tax revenues are discretionary of the center. What do you mean of discretionary? Not compulsorily. They might. There is one weird word called S-cheat. Heard about S-cheat? Not X-cheats. What is this S-cheat? No idea? Suppose a person passes away without writing any will and there is no legal heir, then that will be taken by the government. That is called as S-cheat. Jaya auntie, heard about Jayamma? She passed away. Some of the properties, no will is written, no legal heir is claiming, then state can take over them. So S-cheat is not a tax revenue. S-cheat is a non-tax revenue. Okay? Apart from that, some fee is collected, profit is made by PSUs and RBI transferred around 2,10,874 crore only. Profit made by PSUs is going to the government, non-tax revenue. What does it mean? What is public sector undertaking? At least minimum 51% ownership is there with government. If it makes profit, profit is going to government. Non-tax revenue only? It is non-tax revenue. What does it mean? Central government will not share with the states. Did you understand? So S-cheats, central government need not share. Just now I said. Surcharges, central government need not share. So profit made by PSUs, central government need not share with the states. The reason being, It's not part of divisible pool of taxes. Then Finance Commission. So 16th Finance Commission is appointed. Arvind Panigari is the chairman. Members also you supposed to know. And one extra terms of reference is added. There is climate mitigation funds. Earlier finance commissions did not exclusively have terms of reference related to climate mitigation. Now why climate mitigation, sir? Global warming and climate change. That's the reason why 16th Finance Commission, one extra terms of reference is added along with it, divisible pool of taxes. So horizontal devolution, vertical devolution, grants in aid, backward area grants, along with that, one extra future climate mitigation funds also. Green cover also they are considering. So this is in brief about center-state relations. Who appoints Finance Commission? President only. So then we'll come to emergency provisions, because again emergency provisions also are important. But overall if you look at, so patience is there. Can you cover emergency provisions also briefly? Because again time is limited. Samayam ledu mitrama. So briefly only. Anyway, because federalism we covered, related topic only, it won't take much time. So emergency provisions, again clarity is important. National emergency, president rule, financial emergency. So what is national emergency, sir? Which article? Article 352. So what does national emergency talk about? What does article 352 says? In case of external aggression, war, armed rebellion. Armed rebellion. See, before 42nd Constitutional Amendment Act, internal disturbance was there. That was replaced by armed rebellion. So national emergency can be introduced based on war, external aggression, armed rebellion. Sir, why? Because together as a nation we have to protect ourselves. One of the fundamental duties to defend your country, to defend your nation, remember? So in those circumstances, President can proclaim after receiving a written recommendation from the cabinet. The reason why they brought in is after 1975. So 44th Constitutional Amendment. National emergency in 1975 because of internal disturbances only. Because of internal disturbances only. That's the reason why 44th Constitutional Amendment Act clearly says President cannot declare simply emergency like that. He has to get recommendation, written recommendation from the cabinet. The reason deliberately they have done it so that the powers are not misused. Because if you see an emergency movie, you will understand. India is Indra, Indra is India. India is Indra, Indra is India. Meaning whatever I say that is constitution, whatever I say that is rule. Anyway, she has learned the lessons slowly. But if you look at imposition, proclamation of national emergency is under judicial review. Proclamation of national emergency is under judicial review. Yes, after Minerva Mills case. After Minerva Mills case, the procedure of proclamation of national emergency is under judicial review. Why, sir? They cannot simply do whatever they want. Checks and balances are given. Apart from that. So suppose national emergency is declared by the president. They should be approved by both the houses within 1 month from the date of issue, according to 44th Amendment. If approved, look at the word, national emergency, if declared within 1 month, both the houses have to approve it after that. So if declared, means national emergency is declared, accepted by both the houses. How long it can continue? National emergency will continue for 6 months. How long it can be extended? Infinite time, but for every 6 months, periodically should we take approval? Periodical approval is required. What does it mean, sir? Look at the word. If approved, it can continue for 6 months, can be extended to infinite with approval for every 6 months. Meaning, at a time we are imposing national emergency for 6 months, continued for 6 months. Before expiry of 6 months, again we are taking approval and keep on expiring. How much time we can continue like that? Infinite time. So 44th constitutional amendment got so many checks and balances on imposing national emergency because they understood what is national emergency after 1975. Because of too much of power. Again, if you look at approval for continuous, meaning to continue the national emergency after completion of 6 months, approval of either of the houses by special majority is required according to 44th constitutional amendment only. Now if you look at all these are brought in 44th Constitutional Amendment Act to prevent the excess power of concentration in the hands of the President. That's the reason why written request from the cabinet is required. And 6 months, you can continue for infinite period of time, but periodically for every 6 months, you have to take the approval. All these are to put a check and balance on national emergency. Again, how this national emergency can be expired? How it can be revoked? How it can be revoked? President can revoke. Okay. So revocation by simple majority. So how revocation by Lok Sabha? At least 1/10 of the Lok Sabha members will write to revoke, and with simple majority it can be revoked. So this is national emergency. How many times national emergency was introduced in India till now? Trick in the question. How many times national emergency because of internal disturbance was created, announced? Only one time, 1975. That after that only it is changed as armed rebellion. Again, if national emergency is introduced, state government is not suspended, but complete control is taken by the center. I repeat, in case of national emergency under Article 352, state government is not suspended. However, center will take complete control. Correct? So Parliament can make a law on a state subject during national emergency. Yes? Obviously yes. Then when national emergency is introduced, what is the impact on fundamental rights? Article 20, Article 21 cannot be suspended any time. Correct? Only when national emergency is introduced in case of, come on, look at the word. Article 19. When Article 19 will be suspended? Automatic suspension of fundamental right only when? Only when? External aggression. External aggression. So what does it mean? If national emergency is introduced because of internal disturbance, can Article 19 be suspended? No. So Article 2021 can be suspended? Cannot be suspended? Cannot be suspended in any case of national emergency. Article 19 be suspended only when emergency is introduced not because of internal, because of external aggression. Then Article 19 can be suspended? Yes. So national emergency, if you look at, is subject to judicial review. Yes. After minimum milk judgment, yes. Proclamation of national emergency under Article 350 is subject to judicial review. Then come to President rule. The word President rule is mentioned in the Constitution. Actually, President will not come and rule. Governor will rule on behalf of the President. Correct? The word President rule is not mentioned in the Constitution. The word, it is called as President rule, but President will not rule. Who will rule? Again, it's also known as state emergency. So if you look at Article 356, Article 365. So what is 356? President can proclaim President rule or state emergency if satisfied action with or without governor's report. Look at the word. With or without governor's report. Governor's report is not compulsory for imposing President rule. Which means President can impose President rule with or without report from the governor. Then one more condition. Article 356. What is Article 356? In case of constitutional failure in a state, center will take over the state. Yes, but what is failure of constitutional machinery? Not complying with the center's orders. So if you look at one more condition is that Article 365. 365 is state fails to comply with the direction of the center. 365 is state is not following the orders of the center. 356 failure of constitutional machinery. What is failure of constitutional machinery? No political party is in a position to form the government. Yes? Possible? So coalition government collapsed and governor invited everyone. Nobody is in a position to form with a simple majority. So two conditions. 365 not complying the orders of the center. 356 failure of constitutional machinery. Again, who can proclaim this? President. Must be approved by both the houses. Yes? President rule should be approved by one of the houses or either of the houses or both the houses. Both the houses within 2 months from the date of issue. So again, if approved, it will continue for how much? President rule initially 6 months. How long it can be extended like that? 3 years. But earlier we said national emergency can be extended for Article 352 indefinite period for every 6 months periodical approval. But president rule, once approved 6 months, but maximum it can be extended up to 3 years. Again, continuation. If you want to continue the emergency, at least either of the house, look at the word, either of the house by a simple majority will ensure that it will be continued. Again, national president rule can be introduced in any of the state or overall the state or more than one state. Or president rule is introduced in total throughout the state or any part of the state also. Any part of the state also? Any part of the state also. Again, if you look at revoked by president. So president rule is revoked by president only, because who is imposing president rule? So any time, no parliamentary approval is needed for revocal. To revoke president rule, parliament approval is required. No. Why? Because center order is not followed and state constitutional machinery is failed. That's the reason why it is introduced. But whenever they feel that, so president can revoke president rule any time. But compulsorily, no parliamentary approval is needed. Can we say that? Again, during president rule, governor is the highest authority of the state, working on behalf of president. Working on behalf of president. President dismisses state council of ministers during president rule. President dismisses state council of ministers during president rule. Constitutional machinery is not there. That's the reason why we are imposing president rule. Apart from that, chief secretary will work according to the orders given by the governor. Yes, that's why that is called as president rule. And finally, financial emergency. Financial emergency is mentioned in which article? Article 360. How many times financial emergency is introduced in India till now? No. So what is financial emergency? A president feels that the economic crisis is happening in country and it is not economically viable to operate and run the services, then if president is satisfied that to protect our nation from the financial crisis, financial emergency can be introduced under Article 360. What is the approval process? Must be approved by both the houses of parliament within 2 months. Within 2 months, both the houses should approve it, accept it. Apart from that, resolution can be passed by simple majority. and continuously, indefinitely till it is recalled, or you can say Constitution can continue it till it is revoked. And how long financial emergency maximum can be imposed? How long financial emergency can be imposed? Just like national emergency, indefinite time for every 6 months. President rule, maximum 3 years. Like that, how long financial emergency can be imposed continuously? Constitution did not specify. Maximum time frame of the financial emergency is not specified in the Constitution. It only says it can be continued indefinitely till it is recalled. That's all. Like 3 years time is there in case of president rule? Like that, it is not mentioned. But how many times financial emergency is introduced in India? Not even once. But BOP crisis happened in 1991. We did not introduce financial emergency even though our economy is in crisis. BOP crisis 1991 because of external reasons and internal reasons, mainly because of twin deficit problem. High current account deficit, high fiscal deficit. What is high current account deficit? Imports are more than exports. What are major imports? Crude oil, petrol, gold, semiconductor chips, electronic items, that are major imports of India. Semiconductor chips. What are major exports of India? Textiles, cosmetics, organic products, that are major exports of India. Imports are more than exports. We are not in a position to pay to the world. We don't have sufficient foreign currency reserves. So, in fact, forex reserves available to RBI was less than $1 billion in 1991. So, current account deficit, fiscal deficit, expenditure is more than income. So, this is popularly referred as twin deficit problem of India, which is the reason for BOP crisis 1991. But why financial emergency is not introduced? Even though financial emergency situation happened, you are telling to the world that you are bankrupt. Nobody will give loan to you, no investment will come. That's the reason why, even though situation of economic crisis happened in 1991 in India, but still we did not impose financial emergency. So in case of financial emergency, President can ask the government servants to work without salary. Will you work? Possible, because nation first. Correct only? Of course, at least on paper. So concept of emergency provisions India borrowed from Government of India Act 1935. Or Germany. Germany. Suspension of fundamental rights in case of emergency borrowed from. Got the difference? So Government of India Act 1935, emergency provision, suspension of fundamental rights in case of emergency. Again, just now I said, if you look at 1962, Chinese aggression. Chinese aggression only? So national emergency was introduced. Continued till 1968. Yes, apart from that. 1971, Indo-Pak War. Indo-Pak War. 1975, internal political crisis. So after 1977 till now, no national emergency is introduced in India. After 1977, no national emergency is introduced in India. Correct? Because that situation did not come. External emergency can be introduced under Article 352 in case of two, war and external aggression. So in case of internal emergency, armed rebellion. Correct? 44th Constitutional Amendment Act substituted the words armed rebellion for internal disturbance. Meaning earlier what was there? Internal disturbance was there. Earlier what was there? Internal disturbance was there or armed rebellion was there? Before 44th Amendment, internal disturbance was there. That words are replaced by armed rebellion. Again, 42nd Amendment 1976 says, President can limit operation of national emergency to specified part of India. Throughout nation, national emergency may not be introduced. It can be specified also to some part. Yes. Again, we said maximum time national emergency can continue after periodical approvals. Infinite time. For president rule, maximum time 3 years. Financial emergency, constitution does not specify anything, but again, if you look at overall, state emergency introduced in India for more than 120 times till now. President rule is imposed for more than 120 times till now. And Manipur, recent Manipur only. That's the reason why 356, 365, both. What is the difference between 356 and 365? Failure of constitutional machinery 356, not complying the orders of the center 365. Misuse of president rule many times. That's the reason why. Is it subject to judicial review? Subject to judicial review? Yes. Apart from that, if you look at overall, president rule is discretionary decision of the president alone. President rule or emergency is taken by president and the advice of the council of the ministers. Advice of council of ministers only. Parliament written recommendation supposed to come again. So if president satisfies, which means president feels it is required, but of course it depends upon the type of the emergency. Is it under Article 352? Is it under Article 356? Again, so SR Bommai case, judicial review, Article 356 is brought under judicial review. Simply you cannot say failure of constitutional mission and impose president rule because the opposition parties are in power. Horse racing is going on. What is horse trading? Buying MLAs at the time of floor vote is called as horse trading, meaning buying horses like donkeys and buffaloes. They are buying MLAs. I mean, simple majority, governor will give a date to move the majority floor. So at the time of that, before itself, opposition parties are purchasing ruling party MLAs. Ruling party MLAs are purchasing opposition party MLAs. That word is called as horse trading because horses are purchased with each other. So on the day of the floor voting, if simple majority is not there, what happens to government? Government will collapse. So also, in fact, Article 356 is more misused than used properly. More misused, we said. Then what is called as hung assembly? So at that time it is whose duty to, whose discretionary power to invite a person to form the government? Governor. So just because governor discretion, he should not invite whomever he likes. There should be a proper procedure also. Apart from that, if you look at, in case of national emergency, all fundamental rights can be suspended. All fundamental rights can be suspended except Article 20 and 21. In case of financial emergency, government need not pay salaries to employees. Of course, during the national emergency only, don't worry. During financial emergency only, after that they'll pay. And sometimes math the following is asked. 356, failure to comply the orders of center. Correct? 356, failure of constitutional machinery. 352, national emergency. 360, financial emergency. Then when LKG question is asked. During normal circumstances, India functions as federal system. In case of national emergency, it gets transformed itself into unitary system. Okay? So this is briefly about center-state relations, emergency. So fully we covered center-state financial relations also, legislative relations also, administrative relations also. So probably tomorrow we'll cover amendment procedure, important amendment, constitutional bodies, non-constitutional bodies. We will see how much of time permits. For prelims purpose, yes. Constitutional bodies, non-constitutional bodies. And sometimes they're asking, amendments also math the following they're asking. But UPSC they didn't ask factual data, brief idea overall. So we'll try to finish as much as possible. So what all we covered? Preamble, DPSP, fundamental duties, fundamental rights, president, governor. Then we covered a parliament, Supreme Court, High Court. Then today we covered center-state relations, local governance also. So hopefully tomorrow we'll try to finish as much as possible. How much ever is possible we'll try to finish. Okay. Thank you.